Yes, Mr. Wardle.
My lords, my lady, good morning.
Morning to you.
I appear for the appellant with Mr. Mould. My learned friends, Mr. Sullivan and Mr. Nixon, appear for the respondent. Can I just start where I'm planning to go in my allotted time? First, I want to say something about the underlying rationale. Secondly, I propose to take you through the main authorities to make good the proposition that it's never been a requirement that when seeking to set aside a judgment obtained by fraud, the victim has to show that he couldn't have discovered the fraud by the exercise of reasonable diligence. Thirdly, I propose to take you through phosphate and then Hunter to make good the point that Hunter did not change that position. Fourthly, I need to show you how the obiter dicta in the first Owens Bank cases were informed, particularly the first one, were informed by counsel's misunderstanding as to what Hunter had decided. This misunderstanding has resulted in the English law taking a wrong turn. Then I want to deal briefly with the Commonwealth cases, certainly the leading Commonwealth cases, and if time permits, I will then say something about Ladd and Marshall and comment briefly about the points the other side make about things like arbitration, limitation, case management, and so on. They may need to wait till my reply, bearing in mind I've got limited time. If I get blown off course, I'm going to try and return to that template.
We'll try not to blow you too far, of course.
Thank you. Dealing with a principle, a key policy principle is that the judgment of a court is final. This extends to argues mattered and decided, as well as material that should reasonably have been brought before the court. There are, however, exceptions to the basic position. One exception is where the judgment has been procured by fraud. If it has, it can be set aside by issuing a fresh claim. Another exception is where fresh evidence comes to light after the event in respect of a matter already decided. As we shall see, historically, the courts have always kept the two separate and continue to do so in Hunter. The fraud exception is justified by the fact that a fraudster should not be permitted to benefit from his own wrong. The court also has an interest in its due process, not being suborned by a crook. So there's no doubt at all that finality does not trump fraud, and that the contrary is the case. What the principle of finality does is to inform the conditions in which the fraud exception applies. There are three essential conditions. First, fraud must be shown to have taken place. It's obvious, but for a judgment to be set aside for fraud, fraud has to be perpetrated. Secondly, the fraud now relied on must not have been an issue before the court delivering the original judgment. Instead, it must be newly discovered, by which is meant post-trial. This requirement is justified because were the very issue of fraud now relied upon already to have been determined, then that would give rise to res judicata. In that event, different considerations would apply. Thirdly, the fraud must have been sufficiently material to the court's decision, without for the moment descending into the competing formulations of that condition, which we deal with in paragraphs 20.2 and 20.3 of our case. One can understand the sense of this. If the fraud had nothing to do with the court's decision, then it shouldn't vitiate the judgment. Assuming these three conditions are fulfilled, then one may ask, what is the justification for imposing a further condition that the claimant must demonstrate that he or she could have discovered the fraud at the time of the original trial by the exercise of reasonable diligence? Could not have discovered, thank you. What can be the possible rationale for a fraudster exceptionally being able to rely on a defence of contributory negligence when those conditions are made out? The courts have consistently taken the view that fraud is a vitiating factor and that those entering into contracts, settlements, court proceedings don't need to be on the lookout for the risk of being cheated. As Lord Justice Denning said in Lazarus Estates, no court in this land will allow a person to keep an advantage which is obtained by fraud. No judgment of a court, no order of a minister can be allowed to stand if it's been obtained by fraud. Fraud unravels everything. The court is careful not to find fraud unless it's distinctly pleaded and proved. But once it is proved, it vitiates judgments, contracts, and all transaction whatever. And as we say in our submissions, that was cited by approval by Lord Bingham in the HIH Casualty and Chase Manhattan Bank case. And for your note, that's paragraph 15 in the electronic bundle. That's at page 1118. The principle of finality is sufficiently satisfied by the conditions I've already addressed. It doesn't point to any further condition. No sound basis for a further condition has been made out, particularly a condition which undermines the general proposition that fraud unravels all. Certainly not a condition which exceptionally provides a defence to contributory negligence. In this regard, it's notable that Lord Clarke in Zurich Insurance accepted the proposition that a representee has no duty to be careful, suspicious or diligent in research. I'll come to that later if I have time, but for your note, that's paragraph 39 of the judgment, which in the electronic bundle can be found at page 2190, and in the hard copy bundles, A4, tab 52, page 1243. The contrast with what has to be shown when seeking to reopen an issue that's already been decided upon is clear. In that event, we are in the territory of res judicata, and therefore different considerations necessarily apply. The interests of finality prevent a party endlessly litigating the same issues, and therefore, or thereby, inform the concept of abuse, at least so far as it's applied in this context. Thus, a litigant can only reopen an issue that has already been adjudicated upon if he or she satisfies some basic conditions. That is, that the evidence is new, it could not have been discovered by reasonable diligence before the trial, and it entirely changes the aspect of the case. If it's not new, or could have been discovered by reasonable diligence, the new claim would be liable to be struck out as an abuse. The respondents, in paragraph 8 of their submissions, electronic bundle 57, core bundle 55, mischaracterise our position by suggesting that our submissions extend to a case where a claimant has lost a fraud case first time round. They do not. It makes no difference that where a claim has been adjudicated upon or an allegation has been determined, it makes no difference that the allegation that the party is seeking to reopen is an allegation of fraud. Provided that issue has been considered and determined against that party, it will give rise to either a cause of action estoppel or an issue estoppel. In either event, the litigant must satisfy the conditions dictated by the authorities on res judicata. Therefore, if Mrs. Takhar had raised and lost the issue of forgery before His Honour Judge Pearl, she would be bound to satisfy the reasonable diligence requirement, as well as showing that the new evidence entirely changes the position. She could not just seek to set aside the judgment on the ground that it had been attained by fraud. The respondents go on to suggest that a due diligence requirement strikes a sensible balance between the competing interests. However, they don't explain why such a condition is necessary, and they don't seek to justify such a departure from the usual way the law views fraudsters. Furthermore, their stance treats the victim of fraud as being in essentially the same position as someone to reopen an issue covered by issue estoppel. And that completely ignores the proposition that fraud is a thing apart. Finally, before turning to the authorities, it's worth observing that the decision of the Court of Appeal in the present case was not based upon its view that the appellant was wrong as a matter of principle. Indeed, Lord Justice Patten appeared to accept the strength of the arguments in support of the appellant's position. See paragraph 52. That's E1116, Core Bundle 114. However, he felt compelled to allow the appeal based on his reading of the authorities, which he thought bound him. Turning now to the authorities, which is my second point today, I want to go through the old authorities, some of them at some speed, to make good the proposition that there was no lack of clarity as to the position before Hunter. We say that all the cases point in one direction, and we also say that when we get there, Hunter does as well. The first authority is Patch and Ward. I'm going to go through these chronologically. You can find that in the electronic bundle. It starts at page 1524. In the hard copy bundles, it's at tab 32 of volume 2. I hope it's going to be easier for when I take you through the authorities, once we've identified where the authority can be found, either in hard copy or in electronic copy, to actually use the page numbers in the original report. Maybe quicker just to get to the right page.
Well, I think if you could give us the electronic number as well, that would certainly be helpful to some of us at least.
Okay, well, we start in electronic bundle then at 1527, and hard copy bundle 640B, and it's the judgment of Lord Justice Kearns. The bill in this case is filed to set aside a decree absolute full.
643, did you say?
640B, I apologize.
I'm sorry.
206.
Bill in this cause is filed to set aside a decree absolute for foreclosure made as long ago as the month of March 1849 and enrolled a few years subsequently. Being a decree signed and enrolled, the matter covered by it has become solemnly raised judicata between the parties to the suit, and the decree must remain, unless it can be set aside either upon the ground of error apparent upon the face of it, upon the ground of new matter subsequently discovered, or upon the ground of fraud. If it's to be impugned for error apparent upon the face of it, or for new matter relevant to the issues in the cause, that must be done by bill of review, the bill in the former case being filed without any leave of the court, in the latter not without leave, and in order to obtain that leave, the applicant must satisfy the court that the new matter is relevant to the issues and could not with reasonable diligence have been earlier discovered. There is here no error apparent upon the face of the decree, neither has any leave been applied for or obtained to file a bill of review upon the ground of new matter discovered. The third ground alone remains, and is that on which the bill is filed, that the decree was obtained by fraud. So pausing there, reference to new matter subsequent discovered, but in the context of new material, not in the context of fraud, which is treated as a separate, standalone ground. Next one is Flower and Lloyd. Electronic bundle, this starts at E1033. Hard copy bundle is volume 1 of A, tab 10. This is the first of the Flower and Lloyd cases. We pick it up, please, in the judgment of Lord Jessel, which electronically you'll find at 1035. Hard copy, we pick it up at 199. And the question, then Master Rolls posed, the question which we have to decide is whether final judgment, having been pronounced by the Court of Appeal dismissing an action with costs, the plaintiff in that action is entitled by motion to apply for leave for a rehearing of the appeal before the Court of Appeal on the ground of subsequent discovery of facts, which show or tend to show that the order of the Court of Appeal was obtained by a fraud practised on the court below. If there was no other remedy, I should be disposed to think that the relief now asked ought to be granted, for I should be slow to believe there were no means whatever of rectifying such a miscarriage if it took place. But I'm satisfied there is another remedy. In the first place, it must be remembered that the old practice remains where not interfered with by the new rules, And secondly, it must be remembered that all the jurisdiction of the old Court of Chancery is transferred to the High Court of Justice. Now, had the Court of Chancery any jurisdiction to give relief in such a case, it plainly had. I will read from the well-known treatise of Lord Redesdale. If a decree has been obtained by fraud, it may be impeached by original bill. And he goes on to say, without the leave of court. But there are very few such cases. In most cases, you must obtain leave. The fraud used in obtaining the decree being the principal point in issue, and necessary to be established by proof before the propriety of the decree can be investigated. And where a decree has been so obtained, the court will restore the parties to their former situation, whatever their rights may be. So there's no doubt that under the old practice, you could have brought an original bill to impeach a decree for fraud and could have got relief if fraud in obtaining the decree was proved. There was another totally different class of case where you discovered subsequent matter which showed that the decree was wrong, although there had been no fraud in obtaining it. That was called a supplemental bill in the nature of a bill of review, which brought the new matter forward and again enabled the court to do justice and get rid of the original decree. So no suggestion that if you're dealing with a case of fraud, there's a reasonable diligence requirement, a clear distinction drawn between original bills on the one hand and a bill of review, and this is an area that was considered in depth by the fairly recent High Court decision in Australia, in Clone, which actually considered the distinction between original bills and bills of review and considered Patch and Ward. The next case is Abeloff and Oppen.
I beg your pardon, just before you go on, do we need to look at Lord Justice James? Because didn't he have some concern about the possibility of proceedings extending ad infinitum?
That's the second Floyd, Flower and Lloyd, which I'll come to later.
I beg your pardon.
Yeah.
Right, thank you.
So where is it going now?
I'm going to Abeloff and Oppenheimer, which is E811,
Which tab?
tab, bundle A, tab 1,
Right, thank you.
and then it's pages 816 to 817 for Lord Coleridge. Now, this is the case, as I'm sure you're well aware, dealt with foreign judgments and what the rule in respect to foreign judgments were, but some of the observations relate to the English position, as we read it, and we can pick it up on page... Sorry, I'm in the wrong place. We can pick it up on page 6. That's 816, the electronic bundle, and it's Lord Coleridge's judgment towards the bottom of the page, about 5 lines from the bottom. Non nostrum est tantus componere lites. It's enough for me to say that the English courts do enforce obligations created by judgments, that it's always been held in the courts of this country to be an answer to an action upon a judgment, that judgment has been obtained by the fraud of the party seeking to enforce it. This principle has been laid down in the broadest terms by de Grey, CJ, in the answer to the 2 questions of the House of Lords in the Duchess of Kingston's case. One, namely, that fraud is an extrinsic collateral act which vitiates the most solemn proceedings of courts of justice. Lord Coke says it voids all judicial acts, ecclesiastical or temporal. And then the bottom of that paragraph, the learned judge says, about 6 lines from the bottom, from the time of the decision in the Duchess of Kingston's case until the present time, it's been held that fraud of that kind can be pleaded in the courts of this country to an action on a judgment, and that if it can be proved, it vitiates the judgment and discharges the defendant from the obligation which otherwise be thereby created. And if we go on to the judgment of Lord Justice Brett...
When Chief Justice de Grey speaks of extrinsic collateral act, what's he referring to?
I
Extrinsic?
think he regards that subsequently discovered fraud is treated by the courts as being extrinsic or collateral to the issues that were before the court. That's how I read it. And if we can go on, please, to Lord Justice Brett's judgment, which starts electronically at 821 in hard copy version at page 11. First complete paragraph on 11. The action which the present appeal is brought was commenced in order to enforce an obligation acknowledged by the English courts. I don't stop to inquire why the English courts have recognised that obligation, but it's clear that if a judgment for the payment of a sum of money has been obtained in a foreign court, an action may be brought on that judgment in an English court, and judgment may be recovered upon it in England. The obligation that's asserted in the English action against the defendant is an obligation imposed on him by the judgment of the foreign court. I cannot help thinking that the same doctrine which is now asserted with regard to a foreign judgment would be applicable to an action brought on a judgment obtained in an English court, other than the court in which the action is brought. There may be a difference where it's sought to enforce by the process of a court a judgment of that very court, because if that judgment has been obtained by improper means, the objection doesn't arise in a new action brought on that judgment, but it arises with regard to the process of the court to enforce a judgment of its own. In a case of that kind, it was perhaps formally necessary to proceed in a court of equity in order to get rid of the judgment, but I doubt whether it was necessary because, at least in my opinion, a court of common law would have in the exercise of their own discretion set aside a judgment procured from it by deception. And with regard to an action brought on a foreign judgment, the whole doctrine as to fraud is English and is to be applied in an action purely English. Then we go on to page 13, internally page 823, I hope. Stand corrected. At the bottom of page 13, the learned judge says this: with one exception, none of the authorities cited before us in the least militate against our decision. They all seem to show that the fraud of a party to a suit is an extrinsic and collateral act which will vitiate the judgment. That exception is to be found in the doubts expressed by Lord Justice James, with the assent of Thesiger, L.J. and Flower and Lloyd. That's the second Flower and Lloyd that Lord Kitchen was asking me about. It seems to me that the fraud alleged in that action was probably fraud on the part of certain servants of the party and not fraud brought home to the party himself. Moreover, it was, as I understand, fraud committed not before the court itself at the trial of the action, but previous to the case being brought to a hearing before the court. If it's to be taken that the doubts of James and Thesiger, Lord Justices, related to a fraud of a party to the action committed before the court itself for the purpose of deceiving the court, I cannot, after having heard the present argument, agree with the doubts expressed by them. So, my Lord Kitchen, at this stage I wasn't going to go back to that, but if in due course there's time, I will do so. But also Hunter said that the Flower and Lloyd, second Flower and Lloyd case, overstated the position. So that's Abeloff, my lords. The next one is Boswell and Coates, electronic bundle 928, volume 1 of the hard copy, tab 6. Then we're going to the Earl of Selborne's judgment, electronically starting at 9:30, hard copy starting at 116D. Pick it up at the bottom of page 116D. I'll not lay four lines in the end. I will not lay stress upon it being a judgment of this House in the present case, because I think it right to assume that if a judgment of the Court of Chancery or of the High Court is in a proper way proved at the hearing of the cause to be obtained by fraud, it is one which the Court can remedy. I say that not by any means dissenting from the spirit of his observations made in Flower and Lloyd by that great judge, Lord Justice James, and concurred in by Lord Justice Thesiger, that the Court ought to be even more than usually cautious how it attends to all sorts of reasons which may be brought forward, plausible upon the face of them, for disturbing such a solemn judgment, having regard to the enormous mischief of unsettling the principle on which the doctrine of res judicata is established. Upon that point, I'll only add this, that it seems to me that in every case of this kind, if a motion to stay an action is so made, the Court ought to receive such evidence pro and con as is material to the question whether there has really been, since the former judgment, a new discovery of something material in this sense, that prima facie would be a reason for setting the judgment aside if it were established by proof. We say that sets out the test, and we say that that's been followed consistently. In the Court of Appeal, Lord Justice Patten, don't need to look it up, at paragraph 40 of the judgment, considered this wasn't a much assistance either way, but we say in response to that if Earl of Selborne thought there was a condition to be imported from the old bills of review, into a setting aside, he would have said so. We then go on to Birch and Birch, which is also in bundle A1. Electronically, it's page 915, and it's tab 5. There's a judgment, Lord Justice Cozen's Hardy, which we can pick up at 113 hard copy, electronically 923. Well, I'm sorry, I do apologise. We probably ought to start at 112 922. Lord Justice Cozen's Hardy, with whom Lord Justice Stirling agreed, as you'll see above, read a judgment which, after stating the facts as above, he continued, now it's plain that in the action tried before the President, this distinct issue was raised whether the alleged will was signed by Birch. The judgment in that action is binding upon the plaintiff, unless and until it's set aside. This is not an appeal by the plaintiff from that judgment or an application for new trial. The present action is an independent proceeding to set aside that judgment on the ground that it was obtained by fraud. I don't doubt that such an action may be maintained at least when the party has been procured by the fraud of a party to the action. And he refers to the facts in Boswell Coates, and I think we can pick it up on the next page, 7 lines in, starting the judgments. The judgments of the Court of Appeal of the House of Lords in Boswell and Coates contain some important observations as to the mode in which a motion such as that, which is now before us, ought to be dealt with. Lord Selborne points out that it's not sufficient for the plaintiff to allege fraud. It's the duty of the court to receive such evidence, pro and con, as is material to the question whether there really has been, since the former judgment, a new discovery of something material to disturb the former judgment. And A.L. Smith, Lord Justice, states the plaintiff must show a reasonable possibility of the alleged fraud being established. Again, no suggestion of a due diligence requirement. And then we can again go on to Hip, Fong and Neosha, Privy Council decision. Electronically, each starts at 1153. Hard copy, bundle A1, tab 16.
Which tab, please?
16.
16, madam.
16,
I'm sorry.
No, I think you did say 16. I failed to pick it up.
I mean, in many of these cases, you're relying on the absence of any reference to,
Yes.
but unless on the facts such a reference was germane or the point had been taken, how helpful is it simply to point to the fact that it isn't dealt with?
Well, they were laying down the test, is what I would say to that. And we say the subsequent cases show the distinction being drawn.
Well, they were laying down the test so far as relevant to the case before them, but no judgment can be treated as necessarily comprehensively addressing every aspect of a principle of law that might arise in other cases.
Well, that's certainly true. If they were looked in isolation, and that's all I had, I would accept there's something in what I say respectfully, but it's when you see them, when you realise that the starting point of all this, there was a distinction. Going back to Patch and Ward, there was a distinction to be drawn, the original bill, fraud, no reference to reasonable diligence, but reference to reasonable diligence with bills of review. And no one said anything to cut across that since then. So it's not just the tests, it's not just looking at Boswell and Coates and Birch in isolation, it's looking at them against the background where the courts treated as axiomatic that for an original bill you didn't need to show reasonable diligence, whereas you did for new material. And that we'll follow it right through to Hunter. We will see the same being said both by Lord Denning, but more importantly, Lord Justice Gough. And the reason it's more important is, of course, it was Lord Diplock who followed Lord Justice Gough's judgment in the House of Lords. And Lord Justice Gough, when we get there, draws that distinction. So I say that when taken in isolation, yes, maybe, looked against the difference between an original bill and a bills of review and where they put the reasonable diligence test in that distinction, then these observations in Boswell and Coates and Birch are of some assistance.
But you're saying that it shows that the policy of the law is sufficiently satisfied by a requirement that the fraud should be shown by convincing proof.
Exactly.
And that's what needs to be protected. And maybe
Exactly.
also the court will have some discretion as an abusive process about all this to bring in take a holistic view of all the factors in the
If you
case.
sat on the evidence knowing before the first trial, that would be abusive, for sure.
Yes.
But
So
if it's
that-
newly discovered and you prove the fraud, and then you're entitled to have the judgment set aside.
So is that not a broad merits-based judgment
No.
in Johnson and Gorwood?
No, we say not. No, it's you have to you issue a new action, you prove the fraud. If you prove the fraud and you satisfy the three conditions, then you have the judgment set aside. If you don't satisfy the three conditions, you lose.
But there's no residual discretion in the
No,
court?
we say not.
Thank you.
I was going to take you now to Hit Fung, which is, I think I've already given you a citation, but it's just in case I haven't, it's E1153, volume A1, tab 16, 317. And just from the head note on page 317, which is our 317, to obtain a new trial upon the ground that fresh evidence has been discovered if no charge of fraud or surprise is brought forward, it must be shown that the fresh evidence would be conclusive. But that consideration does not apply to a case of surprise, much less to one of fraud. If a judgment is affected by fraudulent conduct, it must be set aside. And we can go on in that to 322, the judgment of Lord Buckmaster, where we say he draws a clear distinction between, on the one hand, an application for a new trial on the basis of newly discovered evidence, and on the other hand, cases of fraud and surprise, which he treats very differently. And the condition of the evidence being unobtainable only applies to fresh evidence in a case not involving fraud. And we can pick it up at the bottom of page 322, 4 lines from the end. It is, however, urged on the appellant's behalf.
Electronic number, please.
I just do apologise, 1158.
Thank you.
4 lines from the bottom. It is, however, urged on the appellant's behalf that the learned judge's conclusion was due to a misapprehension on his part of a decision in the House of Lords of Brown and Dean. In that case, it was stated, in the opinion of Lord Lawburn, that when an application is made for a new trial on the ground of discovery of new evidence, must at least be such as presumably to be believed, and if believed, would be conclusive. But that case had nothing to do either with fraud or with surprise, as was indeed pointed out. It dealt merely with the claim for a new trial based on the ground that further evidence could be obtained that wasn't obtainable when the trial took place. Fraud or surprise or both are the ground of the application in the present case, and the learned judges were in error in thinking that the authority in itself had any direct and present application to the matter they were considering. In all applications for a new trial, the fundamental ground must be that there's been a miscarriage of justice. If no charge of fraud or surprise is brought forward, it's not sufficient to show that there was further evidence that could have been adduced to support the claims of the losing parties. The applicant must go further and show that the evidence was of such a character that it would, so far as it can be foreseen, have formed a determining factor in the result. Such considerations do not apply to questions of surprise and still less to questions of fraud. A judgment that's tainted and affected by fraudulent conduct is tainted throughout, and the whole must fail. But in the present case, they are unable to say that such a case has been established. So a clear distinction being drawn yet again between discovery of new evidence, which must be conclusive, absent fraud, and a case of fraud. And it's notable that Lord Justice Patten said perhaps we ought to look at this at paragraph 52 of the judgment, E116. Core 113 to 4. Where he quotes, or sets out part of the quote from Lord Buckmaster's judgment, and then says, at 52, the passage quoted above contains no reference to the...
I'm sorry, can
I'm
you
sorry.
give me the electronic page again, please?
116.
116, thank you.
Yes. And at paragraph 52, he says, the passage quoted above contains no reference to the due diligence condition. But the quote he's set out in his judgment starts 4 lines further on. And if you go back to Hip Fung, where the distinction is drawn between a claim for a new trial based on the ground that further evidence could be obtained that was not obtainable when the trial took place, that is clearly looking at the due diligence requirement, what you have to show if you're adducing fresh evidence. And a clear distinction is being drawn, and the same distinction, same point was made by Lord Buckmaster in the Genesco and Beard case, which we find electronically E1201, that's tab 2, that's tab A2, bundle A2, I apologise, tab 19.
Beg your pardon, could you give me the electronic number again?
Of course, it's E1201.
Thank you.
And we can pick it up electronically at page 1203.
Internal numbering?
Internal numbering, for the hard copy it's 357, top of the page it's 300. And halfway down that page, on the hearing before the Court of Appeal, affidavit evidence was filed in support of the appeal and answered. It's on these affidavits that the new trial was ordered. In part, they consisted of statements as to evidence not forthcoming at the trial, and in part on allegations of fraud. The former didn't form the foundation of the judgment of the Court of Appeal, indeed they couldn't have done so, for there was no sufficient explanation of why the evidence had not been available at the trial and why no application for adjournment had been made. These statements don't merit examination and may be disregarded. It's the charge of fraud that's the sole reason supporting the judgment now under appeal. Viewed simply as a matter of procedure, the course taken was irregular. It's long been the settled practice of the court that the proper method of impeaching a completed judgment on the ground of fraud is by action, in which, as in any other action based on fraud, the particulars of the fraud must be exactly given and the allegation established by the strict proof such a charge requires. In Flower and Lloyd, the Court of Appeal, consisting of Lord Justice Jessel, James and Bagley, held there was not jurisdiction in the Court of Appeal to entertain a similar application with regard to one of their own judgments. Lord Justice James stated, you cannot go to your adversary and say, you obtained the judgment by fraud and I have a rehearing of the whole case until that fraud is established. Flower and Lloyd and other cases show that the right procedure for that purpose is by action. That, however, there is jurisdiction in special cases to set aside a judgment for fraud on a motion for a new trial may be accepted. Hip Fung is such a case, but it should be remembered that this case had come up to the Privy Council on this procedure, and the board would naturally be unwilling to defeat a case at its last stage on such a ground. If, however, for any special reason departure from the established practice is permitted, the necessity for stating the particulars of the fraud and the burden of proof are no whit abated, and all the strict rules of evidence apply. The affidavits used must therefore be examined as on final trial. Every particle of hearsay evidence in reference to documents not produced must be excluded, and must be kept constantly in mind that the rules which permit on interlocutory proceedings hearsay evidence, where the exact source of the information is forwarded, have no more application than they would possess were the deponent a witness in the box speaking at the trial. I cannot help thinking that it's because these considerations weren't properly placed before and impressed upon the Court of Appeal, they pronounced a judgment which, in spite of the skill of counsel, I can find no ground to support. To explain the reasons for my opinion, some examination of the facts if necessary, the fraud charge related to the claim for the price of the 2 horses alleged to have been sold. Were such fraud properly established, I agree with the Court of Appeal in holding that the whole judgment would thereby have been vitiated. Fraud is an insidious disease, and if clearly proved to have been used so that it might deceive the court, it spreads to and infects the whole body of the judgment. Assuming that the difficulty of procedure is overcome, was such fraud specified and proved here? Again, he's dealing, if I may say so, with the test. Now, this authority doesn't feature in the Court of Appeal's judgment at all, or certainly not directly. The nearest one gets to it is when Lord Justice Patten deals with the Commonwealth authorities, and where he makes a reference to an earlier House of Lords authority. Don't think we need to look that up, but that's paragraph 48 of the judgment, and we assume he has in mind UNESCO and Beard. I was then going to take you to a decision of the High Court of Australia, MacDonald and MacDonald, and you find that electronic bundle 2381. Hard copy, A5, volume 5, tab 59. And this is an application for a fresh trial on the ground of subsequently discovered perjury. And we can pick it up in the judgment of the Chief Justice Barwick, electronically 1433. I do apologise, electronically 2384, hard copy 1433. Clear distinction being drawn between fresh evidence falling short of fraud, where the due diligence requirement applies, and a case of fraud. And we pick it up in the last complete paragraph on page 1433, where he says this: the discovery subsequent to verdict of admissible credible evidence, which couldn't have been sooner discovered by the exercise of reasonable diligence in the circumstances, and which is of such probative value and significance that, taken with the evidence already given at the trial, it will in all probability be decisive of the issues between the parties in a sense opposite to that of the verdict, is a ground for the granting of a new trial. If the court is satisfied the fresh evidence fulfills these requirements, it will generally conclude that therefore the interests of justice demand that the issues be tried afresh. In that event, the circumstances of the fresh evidence may tend to support the conclusion the verdict was obtained by fraud or by surprise or by subornation of witnesses, will not prevent the grant of a new trial on the ground of the discovery of fresh evidence, or require the court to satisfy itself of the fraud, surprise of subornation. Nor, in my opinion, does that circumstance lessen in any respect the stringency of any of the rules which apply to the grant of a new trial upon the ground of the discovery of fresh evidence. The fresh evidence, though it suggests fraud, surprise, or subornation, must yet fully satisfy all the criteria laid down with respect to fresh evidence, warranting a new trial, although it may be that in some cases the tendency of the evidence to show fraud may make it more likely to be conclusive. In my opinion, it would be a misreading of Lord Buckmaster's speech in Hip Fung to conclude otherwise. So pausing there, fresh evidence is a reasonable diligence requirement. Then goes on to say this: but if the fresh evidence doesn't satisfy all these requirements, so that a new trial could not be ordered on the basis of discovery of fresh evidence, but does tend to establish that the verdict was obtained by fraud or surprise, or there's been subornation of witnesses, the court may grant a new trial upon a motion, therefore, though a separate proceeding is clearly the preferable course. If the court itself, on a trial of such issues, finds the fact of the fraud, the surprise, or the subornation of witnesses, as the case may be, to be proved to its reasonable satisfaction, Hip Fung and UNESCO. It's not necessary in that event that the evidence of the fraud, the surprise, though it should be fresh, should be evidence which should be admissible on the issues between the parties, or that it should be found to be probably conclusive of those issues. The court's conclusion upon the fresh evidence before it that the verdict was obtained by fraud, by surprise, or that witnesses were suborned, is sufficient to justify setting aside the verdict and ordering a new trial. So clear distinction being drawn between fresh evidence on the one hand, where there is a reasonable diligence requirement, and fraud on the other, where there is no such requirement. And Mr. Justice Menzies deals with the matter electronically 2394, hard copy bundle 1434I. Halfway down the page, 134I or 2394, he says, the foregoing authorities, I think, justify the proposition that if a new trial is sought upon the ground of the discovery of fresh evidence, which, if believed, would show that a fraudulent case has been presented to the court at the original trial, it was also shown that this evidence was not available at the original trial, notwithstanding the exercise of reasonable diligence, then a new trial will be ordered if the case made out is such as to satisfy the court that in the interest of justice the matter in question should be tried afresh. The proposition, which relates only to the granting of a new trial on the ground of the discovery of fresh evidence, leaves untouched the rule that if by any means it be affirmatively proved that the earlier judgment was tainted by fraud, it will without more be set aside. Thus, for instance, to prove the bribery of a witness or a juryman at the earlier trial by a party would require a verdict given in his favour to be set aside without speculation upon the results of the bribery. So clear distinction again. Fresh evidence, you import the reasonable diligence requirement. Fraud, no. And he then goes on to deal with an article written by Mr. Gordon in the Law Quarterly Review. Since writing the foregoing, I've read an article by Mr. Gordon entitled Fraud or New Evidence. The learned author there takes a somewhat different view than which I've taken. No reference, however, was made to the cases upon which I've based my judgment, namely Hipfung and others. For the reasons which I've given, I regard as too narrow the learned author's propositions that fraud as a ground of review is no exception to the rule that review can only be based on new evidence, that a judgment will not be set aside on the ground of fraud unless it's established by evidence newly discovered, A, newly discovered, B, which could not have been found by the time of the trial by the exercise of reasonable diligence. So they are expressly addressing the question of whether the reasonable diligence requirement applies to a fraud case, and the answer to that is clearly no. And before looking at Phosphate and Hunter, I just want to remind you, and if I have time, I'll take you to them, that there are a number of cases we mention under the Ladd and Marshall part of our statement of case, where the court has made it clear that when considering the admission of fresh evidence under Ladd and Marshall, or under the Ladd and Marshall as applied under the CPRs, the reasonable diligence requirement is watered down and not necessarily followed in cases of fraud. And that's Wilmer, I do apologise, it's Meek and Fleming, it's Scone and Scone, Linton and the Ministry of Defence, and Hamilton and Brodie Britain Racing. And I'll come to them later, but just they support the differentiation that I've outlined to you between fraud on the one hand and fresh evidence on the other. Can we now go to phosphate sewage? Now, there was a problem with the electronic bundle about this. I hope you have a supplemental electronic bundle where you'll pick it up at 2571. It may be page...
We have a supplemental bundle, but there's no 2571.
Do you have a page 16 of your
it's
supplement?
Page 15 of... It starts at page 15 of the supplemental bundle.
Thank you.
I don't think I even have a supplemental bundle.
I think if you've got hard copies, my lord, you can go to A3 tab 34. Before taking through it, can I just outline the facts briefly? This is an important decision. Critically, this was not an application to set aside a judgment obtained by fraud. It was an attempt to reopen a matter that had already been decided by adducing further evidence on the point which was raised judicata. The original proof, it concerned a proof in bankruptcy in Scotland. And the original proof in bankruptcy relied on fraud as pleaded in English proceedings in Chancery Division. And those English proceedings alleged fraud. That original proof was rejected. The trustee's decision was upheld in subsequent proceedings. So that matter was raised judicata. The company then sought to lodge another claim in the bankruptcy. And that second claim was based on the original claim in the Chancery Division, which had been amended. And all the amendment did was to raise a new indicia of fraud. which, if correct, would have resulted in a lower alternative recovery. So it was not a case of seeking to set aside a judgment obtained by fraud. It was a case covered by res judicata, and therefore a case fairly and squarely within the category of fresh evidence where there's a reasonable diligence requirement. The only other wrinkle that you probably need to be told about is that under the Scottish approach, you're entitled to produce fresh evidence, provided you satisfy the reasonable diligence requirement and other requirements, even where you have cause of action estoppel. So with that introduction, I'm going to take you to the judgment, first of all, of Earl Kearns, who, of course, is a judge under a different period. Before we advance, was a judge in Patch and Ward, the first case I told you to. Electronic bundle, I've given you the reference. We can pick it up, and it may be, as you've now got odd numbering. Can I give you internal numbering, please, just for this authority? I think it might make it easier. And pick it up at Lord Kearns, Earl Kearns, at top of the page, 810, setting the scene 5 lines into 810.
That's 24 electronically.
That ought to be...
It's 24.
Ah, thank
It's
you.
24.
And so the top of the page, second line, the result of the decision was the phosphate sewage company represented by the liquidator were held not to have approved and not to be entitled to the debt which they claimed against his state under sequestration. That is res judicata upon those facts and upon those materials to which I referred, and there was no question that it cannot now in any way be set aside. That decision stands as perfect and complete in law. And if we can then go on, please, to internal page 814 at the top of the page. I'm afraid I don't know the number in the supplemental judgment. 28, I'm grateful. And we can pick it up at the first complete paragraph. My lords, your lordships are informed by the learned judges of the Court of Session that although the record was closed in the original proceeding in Scotland on the 3rd of March, proof was not laid in it until the 16th of June 1874, and that it would have been competent and also a matter of course for the phosphate company at any time before the proof was laid on ascertaining this additional fact or these additional facts, if they considered them material, to apply to open the record and close it again. And in case that's a little dense, what this is referring to is that there'd been an amendment in the Civil Action and Chancery Division alleging this new indicia of fraud, and what Earl Kearns is saying, that even though the record was closed, you could have reopened it in Scotland to argue or to bolster your proof of debt by referring to this new indicia of fraud. Now, my lords, these being the facts of the case, my first observation is this. As I understand the law with regard to res judicata, it's not the case, and it would be intolerable if it were the case, that a party who's been unsuccessful in litigation can be allowed to reopen that litigation merely by saying that since the former litigation there was another fact going exactly in the same direction with the facts stated before, leading up to the same relief which I asked for before, but it being in addition to the facts which I mentioned. It ought now to be allowed to be the foundation of a new litigation, and I should be allowed to commence a new litigation merely upon the allegation of this additional fact. My lords, the only way in which that could possibly be omitted would be if the litigant were prepared to say, I will show you that this is a fact which entirely changes the aspect of the case, and I will show you further that it was not and could not by reasonable diligence have been ascertained by me before. Now, I do not stop to consider whether the fact here, if it had come under the description, which is represented by the words res novita veniens in notitiam, would have been sufficient to have changed the whole aspect of the case. I very much doubt it. It appears to be nothing more than an additional ingredient which alone would not have been sufficient to give a right to relief, which otherwise the parties were not entitled to. But it's unnecessary to dwell upon that because it's perfectly clear upon the statement of the present appellants themselves that this fact was within their knowledge before their proof was led in the former action. They were just as free to have had the record open, to have had it stated, so it would come to their knowledge before the record was closed. My Lords, that being so, it appears to me that it would be contrary to the whole principle upon which litigation under the rule of res judicata is made to be final, to allow this litigation to be reopened upon the ground which is alleged. It appears to me that looking at this, as we must look at it, as a fresh litigation commencing in Scotland, those who are commencing it have nothing upon which they can base it, except an allegation that was not in the former litigation, a mention made of the payment of the 15,000. That's 15,000 they discovered they knew had been paid to the agents, and of the shares in which it was turned, and that those facts not having been mentioned upon the former occasion, the phosphate company should therefore be allowed to have a new litigation in order to introduce those facts. They're met at once by the circumstance that the facts were within their knowledge. They might have taken proceedings to brought them before the court on the first occasion. So Earl Kearns was clearly looking at it as a fresh evidence case, clearly applying his mind correctly to the requirement to show they didn't have the evidence before and they couldn't have got it by the exercise of reasonable diligence. And having concluded they had it, that was the end of that.
I mean, it's a Scots law case. It's about the relationship between res judicata and the exclusion of res judicata by res novita veniens ad notitium.
Yes.
And because the claim in the bankruptcy was one of repetition, which is a form of unjust enrichment, because of fraudulent misrepresentation, because the allegation of fraud had been made in the proceedings, they weren't allowed to supplement evidence in support of that fraudulent allegation because they didn't meet the reasonable diligence test, which is implicit in res novita.
Yes. And Lord Hathley deals with it, page 818. I'll give you the page 32 of the electronic.
Yeah.
Lord Hathley asked the question, I come round to this question, is it or is it not the law that if a man has been the victim of fraud of this description in the purchase of the mine or the like, if a man has been led and induced to become the purchaser of property by a variety of fraudulent misrepresentations, he may bring forward his case and enter upon a litigation for the purpose of putting himself in the position in which he was before the fraud was committed, and he is to be allowed to select a certain number of instances of that conduct which led up to the successful result of the fraud, to select as many of those instances as he may think proper, and to put them in the forefront of his proceedings to set aside the transaction, and afterwards, having a certain number of other circumstances within his knowledge, is to be allowed to bring forward those circumstances and say, this is a new medium concrete with regard to the case I'm now bringing forward. This would be an independent case which I should be entitled to assert. If so, we might go through all the various circumstances and acts of fraud which led to the result. We might go through them one by one and year by year, so far as I can see, according to that line of argument. Hardly surprising, that approach. And Lord Blackburn, finally, at 821-2, page 35 of the electronic bundle, and it's the first main paragraph, 2/3 of the way down the page. The question is entirely reduced to this one point, and this one point only. Were the matters alleged new? The phosphate companies say that in the present appeal against the second decision of the trustee, they rely upon the amended bill. The new matters are very easily seen there because they are printed on the bill in red ink. They are alleged in the condescendence upon which the parties proceeded in the present case. They proceeded upon these new matters in their bill, and the question I apprehend comes to be at once, are these new matters? I think it amounts in substance to this. It was found out, but not too late to put it in the pleadings in the previous case, that amongst other means of carrying out the fraud, the Lawsons had been parties to giving a bribe of 15,000 to Engelbach and Keir, who were parties to the fraud. My Lords, upon the question whether there was a new medium concrete addendite, and really a piece of evidence tending to support the former case, I'm very clearly of the opinion that it's only a fresh discovery of evidence, a fresh ingredient tending to prove the fraud upon which they relied. So importantly, this is not a case setting aside a judgment, it's a case of fresh evidence, that didn't satisfy the relevant reasonable diligence requirement.
The medium concludendi, for those not familiar with the Scots law term, are the grounds of action. The proceedings are proceeding on the same grounds of action.
Thank you. That's helpful. Importantly, I'm sorry.
Sorry.
No, my fault. Importantly, my lords and my lady, there's nothing said in that case that impacts on the question that you have to decide. Namely, what do you have to show if you're seeking to set aside a judgment obtained by fraud when that fraud was newly discovered? It's merely an application of well-settled rules of what has to be shown when seeking to reopen an issue that's already been determined. Now, Lord Justice Patten had a very individual take on this decision, and I think I ought to show you that.
Say the fraud allegation wasn't collateral or extrinsic. I mean, what it was, in the first action, fraud was alleged, further evidence of fraud was found, you apply. The second action is seeking the same outcome, and so you apply the doctrine of res noviter, which contains the requirement of reasonable diligence.
Right, quite so. You're saying, I had a good case first time round by loss, I've now got a slightly better case, give me another chance.
It's the same case.
It's the same case, exactly.
But you've accepted at the beginning, haven't you, that where you're seeking to make the same case, but on different evidence, you've got to satisfy the requirement of reasonable diligence.
Exactly. And I gave the example of Mrs. Takhar had raised the forgery issue first time round and lost. We would now be in the territory of fresh evidence and reasonable diligence, and the need to show that the fresh evidence was conclusive. Absolutely. Now,
What you're saying is the Court of Appeal cannot found on phosphate sewage to support their conclusion.
exactly. Now, Lord Justice Patten did have an individual take on this decision, if I may put it like that. And we need to look at paragraphs 38 and 47 of the judgment. And the electronic reference. So electronically, and 47. Electronics 108, paragraph 38. 47 is that one. He introduces phosphate by saying the issue of whether new evidence which could be said to undermine the findings made by the judge in the earlier trial, was a sufficient basis for allowing the matter. With all due respect, that's not quite a correct characterisation of phosphate. It wasn't said to undermine the findings, they just wanted to say, we now have better evidence. There was no attempt to set aside or appeal the findings made first time round. And if we then go on to paragraph 47, which is 114 electronically, Hunter was not, of course, a case in which the claimant was seeking to rely on evidence of fraud in relation to the earlier decision, but Phosphate Sewage Company was such a case. We don't see it like that at all. Phosphate sewage was classically a case of slightly better evidence of something on which you've argued and lost. We then need to go to Hunter and the Court of Appeal. Kilkenny was its name. We find that electronically at E1304, tab 24 of bundle 2, a few words of introduction, if I may, before taking to the judgments. It will be readily apparent to this court that Hunter was a case of res judicata. It was not an attempt to set aside a judgment obtained by fraud, but to reopen an issue that had already been fought and lost. It was a collateral attack on an issue that had been decided, and the fresh evidence related to that issue. And in accordance with established principles, that brought the reasonable diligence requirement into play. And nothing was said in the judgment which cast any doubt at all on the test for setting aside a judgment on the ground of newly discovered fraud. And as I've already indicated, because Lord Justice Goff's judgment was adopted by and followed by Lord Diplock in the House of Lords, it is the most important judgment. But before we get there, I want to show you some passages from Lord Denning's judgment, because he draws exactly the same distinction I've been addressing you about for the last hour between, on the one hand, evidence and fraud, and on the other, new evidence that entirely changes the matter. And it's only the latter, he makes clear, that brings with it a reasonable diligence requirement. And we say, when we get there, that Lord Justice Gough adopted exactly the same approach. But we'll look at that. So Lord Denning's judgment starts electronically, the relevant passage at 1340, and hard copy 485. Bottom of 485, just above G, it's long been recognised that estoppel per rem judicata, or issue estoppel, is not an absolute bar to the matter in dispute being tried again. The party concerned can avoid the effect of the previous decision if he can prove the same to have been obtained by fraud or conclusion. That was the unanimous opinion of the judges in the Duchess of Kingston's case, to which we can now add that the party concerned can avoid the effect of the previous decision if he can show that a new fact has come to light, which he could not have ascertained before by reasonable diligence, which entirely changes the aspect of the case. See phosphate. This is a much stricter test than we require when we admit fresh evidence on an appeal. On an appeal, which is a rehearing, we said that the fresh evidence must be such that if given, it would probably have an important influence on the result of the case. That it need not be decisive. Ladden, Marshall, Scone, Scone. But in order to avoid the effect of an estoppel when there's no rehearing, the fresh evidence must, I think, be decisive. Must be such as to show that the previous decision was wrong. Oath against oath will not do. An important influence on the result will not do. It must be conclusive. And he cites from Brown and Den. It goes on to deal with the Section 11 of the Civil Evidence Act, second paragraph by E. How is a convicted man to prove the contrary? That is, how is he to prove he didn't commit the offence? How is he to prove that he was innocent? Only, I suggest, by proving that the conviction was obtained by fraud or collusion, or by adducing fresh evidence. If the fresh evidence is inconclusive, it doesn't prove his evidence. It must be decisive, it must be conclusive before he can be declared innocent. So exactly the same distinctions we've seen in phosphate and other cases. Due diligence necessary when you have fresh evidence, not necessary when you have fraud, is how Lord Denning regarded the law as at 1980. And Lord Justice Gough, we say on a proper analysis, adopts exactly the same approach. And we get that electronically, 1354, 499. And he starts by acknowledging, without any criticism, the fraud exception. And we pick that up at C. There can, of course, be no doubt that estoppel or abuse of the process of the court cannot be relied upon if the first judgment was obtained by perjury. See Viscount Dillon and Regina and Humphreys. It's well established that in civil cases, a decision which would find an estoppel and amount to res judicata can be impugned if it's obtained by fraud. Duchess of Kingston's case, Aberlef and Oppenheimer. And I think the law is correctly stated in Spencer, Bower and Turner, res judicata, as follows. The fraud necessary to destroy a prima facie case of estoppel by res judicata includes every variety of malafides, malapraxis, whereby one of the parties misleads and deceives the judicial tribunal. So he's accepting the principle that Lord Denning has just outlined. In my judgment, however, and the key to this is the however. So he's now applying this to the facts of his case. In my judgment, however, where the issue at the first trial was which of two parties or their witnesses were committing perjury, it's not sufficient merely to aver that the judgment was obtained by perjury, since that is no more than to say the decision ought to have gone the other way. There must be sufficient fresh evidence to support the allegation. So before looking any further, we're in phosphate territory. It's an issue that's been decided. Someone's come along and say, I want to reopen that issue because I got better evidence. And all that Lord Justice Gough is saying, in those circumstances, it's not just good enough to come along to say the first decision was obtained by perjury. You need to adduce fresh evidence, and therefore you need to satisfy the reasonable diligence requirements. He then looks at Flower and Lloyd And this is the second flower in Lloyd, and the judgment of Lord Justice James says, assuming all the alleged falsehood and fraud to have been substantiated, is such a suit as the present sustainable? That question would require very grave consideration indeed before it's answered in the affirmative. Whereas litigation to end if a judgment obtained in an action fought out adversely between two litigants sui juris and at arm's length could be set aside by a fresh action on the ground that perjury had been committed in the first action, or that false answers had been given to interrogatories, or a misleading production of documents, or of a machine, or of a process had been given. There are hundreds of actions tried every year in which the evidence is irreconcilably conflicting, must be on one side rather wilfully and corruptly perjured. In this case, the plaintiffs had sustained on this appeal the judgment in their favour. The present defendants in their turn might bring a fresh action, set that judgment aside on the ground of perjury of the principal witness and subordination of perjury. And so the parties might go on alternately, ad infinitum. That's really very much sort of the observation of Lord Hathley in Phosphate. But clearly this quote is dealing with where something has already been decided, who's telling the truth below, and you come along and you say, well, actually, they were lying, even though the judges held they were telling the truth. And that's what this judge is addressing. He then looks at Birch and Cozen Hardy's judgment, and Regina and Humphreys, where Lord Halesome said, I'm now down at F. No doubt as was decided in Birch, and as Lord Justice Diplock indicated in Mills and Cooper, where the party seeking to impugn the earlier judgment has no significant new evidence to introduce in support of his claim, he will not be able to avail himself of the exception. So the fraud and fresh evidence points merge into one. That is probably why Mr. Turnell-Samuels didn't rely on the fraud point on behalf of the plaintiffs he represented. And the questions of whether the plaintiffs are entitled to adduce the additional evidence on which they seek to rely, and whether that evidence is sufficient. And he's saying no more than that where the issue that has already been decided is one of fraud, or who was telling the truth, where you seek to adduce fresh evidence about that, you're very much in the fresh evidence territory where you need to establish due diligence. And by citing the word fraud, that adds nothing to analysis. But he's not saying fraud and fresh evidence merge into one as a matter of principle at all times in all circumstances, because he's already cited the correct rule at the previous page at C. And then he's qualified that by, however, where the issue at the first trial is which of the two parties was committing perjury. So it's classically fresh evidence of a matter already determined. It's not an attempt to set aside a judgment on the ground it's been obtained by fraud. And there's nothing exceptional that the Court of Appeal says, and there's nothing that the Court of Appeal says that goes to the question of what has to be established if someone seeks to set aside a decision on the ground that's been obtained by fraud newly discovered.
What is the principle on which he bases the distinction? At D to E, on the previous page, he quotes Viscount Dilhorn saying that the fraud necessary to destroy the estoppel by res judicata includes every type of mala fides and malapraxis.
Yes.
But then he tries to exclude from that broad range the perjury of either the parties or witnesses.
Because all the cases which come within category 1, if I can put it like that, are where that issue wasn't an issue first time round. So what the Spencer Bauer quote is saying, where you have a trial, and after that trial you discover fraud, and that includes every type of mala fides, malapraxis, then you have a right to set aside the judgment, provided you satisfy the 3 conditions. But he says those conditions and that analysis doesn't apply when you've already had your fraud trial. And the reason for the distinction, if I may say, is obvious.
You say, what he says is, in the paragraph at E, in my judgment, where the issue at the first trial was perjury, then you've had your trial.
Exactly. So we're having match 2. We've lost match 1. We're having the same issues. We want the same issues decided again, but we've got a slightly better evidence, my lord. So please let us. And in those cases, it's quite obvious that requirements of abuse lead to the answer that the new evidence could not have been obtained by reasonable diligence and must be conclusive. Otherwise, we litigate ad infinitum. But those principles and those concerns do not apply where first time round fraud wasn't an issue. And then we go to, perhaps before we go to Owen's Bank, can we just look at Arnold and NatWest Bank? Well, I say that, oh, House of Lords, I do apologise. We must go to, the next one is E1183, and it's volume A2, tab 18. And the relevant passage is in Lord Diplock's judgment, 1199 electronically, 354G hard copy. Top of 354G, or 1199, there remains to be considered the circumstances in which the existence of the commencement of the civil action of fresh evidence obtained since the criminal trial and the probative weight of such evidence justify making exception to the general rule of public policy that the use of civil actions to initiate collateral attacks on final decisions against the intending plaintiff by criminal courts of competent jurisdiction should be treated as an abuse of the process of the court. I can deal with this very shortly. For I find myself in full agreement with the judgment of Lord Justice Gough. He points out that on this aspect of the case, Hunter and the other Birmingham bombers fail in limine because the so-called fresh evidence on which they seek to rely on the civil action was available at the trial, or could by reasonable diligence have been obtained then. He examines also the two suggested tests of the character of fresh evidence which should justify departing from the general policy by permitting the plaintiff to challenge a previous final decision against him by a court of competent jurisdiction, and he adopts as a proper test that laid down by Earl Kearns in phosphate sewage, namely that the new evidence must be such as entirely changes the aspect of the case. This is perhaps a little stronger than that suggested by Lord Justice Denning and Landon Marshall as justifying the reception of fresh evidence by the Court of Appeal in a civil action, viz. That the evidence would probably have an important influence on the result, that the need not be decisive. The latter test, however, is applicable where the proper course to upset the decision of a court at first instance is being taken. That is to say, by appealing to a court with jurisdiction to hear appeals in the first instance court, and whose procedure, like that of the Court of Appeal, is by way of hearing. I agree with Lord Justice Gough that in case of collateral attack in a court of coordinate jurisdiction, a more rigorous test laid down by Earl Kearns is appropriate. So he says nothing about the proper approach to setting aside a judgment obtained by fraud. He's just supporting what Lord Justice Gough said when you're in fresh evidence territory in a matter that has already been considered and adjudicated upon. Then can we go to Arnold, which I say supports, Arnold and NatWest Bank, which I say supports and continues the distinction between fraud on the one hand and fresh evidence that couldn't have been discovered on the other. We find that electronically E893, tab 4 of volume A1, and we can pick it up at page 904 electronically, page 94. Lord Keith's judgment halfway down the page just above D.
Sorry, which page are you on?
I'm on page 94, bottom.
No, electronic, please.
Electronically 904.
Thank you.
Sorry. You can pick it up just above B. It's appropriate to commence by noticing the distinction between cause of action estoppel and issue estoppel. Cause of action estoppel arises...
Sorry, which page are you on?
I'm on page 904 electronically, 94 hard copy. 94 at the bottom of the page.
Letter
Just
D, just above
letter
D, it is appropriate.
Ah, yes.
Yes.
I see. Okay,
Sorry.
I'm there.
It is appropriate, if I can start again, it's appropriate to commence by noticing the distinction between cause of action estoppel and issue estoppel. Cause of action estoppel arises where the cause of action in the later proceedings is identical to that in the earlier proceedings, the latter having been between the same parties or their privies and having involved the same subject matter. In such a case, the bar is absolute in relation to all points decided unless fraud or collusion is alleged, such as to justify setting aside the earlier judgment. The discovery of new factual matter which couldn't have been found out by reasonable diligence for use in the earlier proceedings does not, according to the law of England, permit the latter to be reopened. The rule in Scotland, which recognises the doctrine of res novita veniens ad notitiam, is different. See phosphate sewage. There's no authority there, however, for the view that a change in the law can constitute res novita. Principles on which cause of action estoppel is based are expressed in the maxims. I don't think we need to go there. And cause of action estoppel extends also to points which might have been but were not raised. We can go on, please, to page 908 electronically, 98 hard copy. Again, just above E, well, just below D, he refers to Hunter. Goes on to say, it's to be noted there appears to be no decided case where issue estoppel has been held not to apply by reason that in the later proceedings the party has brought forward further relevant material which he could not by reasonable diligence have adduced in the earlier. There is, however, an impressive array of dicta of high authority in favour of the possibility of this. It was argued for the defendants that exceptions to the rule of issue estoppel should be admitted only in the case of the earlier judgment being a default or a foreign judgment, and further that an exception should not be recognised where the appointed issue had actually, as here, been raised and decided in the earlier proceedings, but only where the point might have been, but was not so raised and decided. The later dicta are, however, adverse to these arguments. It was argued there was no logical distinction between cause of action estoppel and issue estoppel, and that if the rule was absolute in the one case as regards points actually decided, so it should be in the other case. But there is room for the view that the underlying principles upon which estoppel is based, public policy and justice, have greater force in cause of action estoppel, the subject matter of the two proceedings being identical than they do in issue estoppel, but the subject matter is different. Once it's accepted that different considerations apply to issue estoppel, it's hard to perceive any logical distinction between a point which was previously raised and decided and one which might have been but was not. Given that the further material which would have put an entirely different complexion on the point was at the earlier stage unknown to the party and could not by reasonable diligence be discovered by him, it's hard to see why there should be a different result according to whether he decided not to take the point thinking it hopeless or argue it faintly without any real hope of success. In my opinion, your Lordship should affirm it to be the case, the law, that there may be an exception to issue estoppel in the special circumstances that's become available to a party further material relevant to the correct determination of a point involved in the earlier proceedings, whether or not that point was specifically raised and decided, being material which could not by reasonable diligence have been adduced in those proceedings. So again, the clear distinction between fraud on the one hand, which can allow you to open something covered by cause of action estoppel, and fresh evidence where there's a reasonable diligence requirement. And that passage, I don't think we need to look it up now, but that passage was, of course, approved by Lord Sumption and Virgin. You can see that in paragraph 32 of our case, electronically E39. Now, it's notable that the first passage from Lord Keith's judgment was cited by Lord Justice Patton in the Court of Appeal at paragraph 33. I don't think we need to look it up. But he doesn't pick up the distinction between fraud on the one hand, allowing you to open cause of action estoppel, whereas on the other, fresh evidence only allows you to open issue estoppel, and again, provided you satisfy the due diligence requirement. By the time we get to Virgin, the laws had taken a wrong turn because of the two Owens Banks cases.
Yeah, is it your submission that Lord Keith was right to hold that there was this distinction between cause of action estoppel and issue estoppel?
Yes, I'm certainly not seeking to go behind that.
That makes the phosphate sewage case even more irrelevant because because it was dealing with the Scottish equivalent of cause of action estoppel.
Understand that.
Where there was, to which the doctrine of res novita was applied. And Lord Keith is here saying, well, in English law, that wouldn't happen.
Yes, but the Court of Appeal did adopt phosphate, the approach in phosphate, as being applicable to fresh evidence covered by issue estoppel.
Issue estoppel.
Yes. We then take the two Owens Banks cases. Now, in our written case, we deal with these together in paragraph 27. That's Owens Bank and Bracco and Owens Bank and Etoile Commercial. hope it may add to the clarity of our submissions today if we deal with them separately. And before taking you to Owens Bank and Bracco, can I just emphasise 2 of the 3 points we identify in paragraph 27 of our case? The statement made by Lord Bridge, as we'll see, was obiter. That's because the decision was dealing with the enforcement of foreign judgments and not the setting aside of a domestic judgment on the grounds of fraud. And there was no debate about the position and no issue that the House was asked to decide on this subject. Neither Hip Fung Hong nor Genesco were cited. Now we find the judgment in the electronic bundle starting at E1460, A2, tab 30. And before I forget, I'm afraid there's an error in our written case. I refer to Lord Bridge's observations being at 459 to 460 in the original authority. It's actually at 483 to 4 when we get there. This was a case of enforcement of foreign judgment, and if you see the citations on page 1461 to 2, our internal 596, 7, 596 to 8, in fact. We don't get Genesco and Beard, we don't get Hip Fung. And Lord Bridge's observations can be found at 1500. Eternal 622M at the bottom of the page.
M,
thank you. And just below E, Lord Bridge says this: it's submitted for the bank the language of section 92D must be construed as qualified by the common law rule that the unsuccessful party has been sued for judgment is not permitted to challenge that judgment on the ground that it was obtained by fraud. Unless he is able to prove that fraud by fresh evidence which was not available to him and could not have been discovered with reasonable diligence before the judgment was delivered. Here it is said there was no such fresh evidence. This is a rule to be applied in an action brought to set aside an English judgment on the ground that it was obtained by fraud. The rule rests on the principle there must be finality in litigation which would be defeated if it were open to the unsuccessful party in one action to bring a second action to relitigate the issue determined against him simply on the ground that the opposing party had obtained judgment of the first action by perjured evidence. Your Lordships were taking the course of argument for the many authorities in which this salutary English rule has been developed and applied, which demonstrate the stringency of the criteria in which the fresh evidence must satisfy if it's to be admissible to impeach a judgment on the ground of fraud. I don't find it necessary to examine these authorities. The rule they establish is unquestionable, and the principle on which they rest is clear. The question at issue in this appeal whether the defendant is seeking to elicit the enforcement against him of a foreign judgment, either by an action on the foreign judgment of common law or under the statutory machinery for the enforcement of foreign judgments, is placed in the same position as if he were a plaintiff in an action seeking to set aside the judgment of an English court on the grounds obtained by fraud, and therefore can only rely upon evidence which satisfies the English rule. Answer to that question was no, but there had been absolutely no debate about this point. The parties were in agreement as to what the principles were, and the reason why the court went wrong, if I may respectfully say so, is because they were misled by counsel. And we can see what's happened if we go first of all to the submissions made on behalf of the appellant, which we find at 1492 in hard copy 622E. Halfway down that page, start between E and F. Overruling Abeloff involves qualifying Rule 44 of Dicey and Morris. The judgments in Abeloff ignore completely the doctrines of cause of action and issue estoppel and the relationship between these and the doctrine of obligation. They're therefore wrong in
622E, did you say?
622E, starting between E and F. Internal page, top of the page, 475.
Right, sorry. Right.
Between E and F, overruling Abeloff involves qualifying Rule 44 of Dicey and Morris. The judgments in Abeloff ignore completely the doctrines of cause of action and issue estoppel and the relationship between these and the doctrine of obligation. They're therefore wrong in principle. The rules ought to be the same, at least where a judgment on the merits in a common law jurisdiction is in question. Indeed, they were the same until Abeloff, for the English rules as to the circumstances in which an English judgment can be impeached for fraud consisting of perjury, see Hunter in the Court of Appeal, approved in the House of Lords. The cases show that the fraud and fresh evidence rules have merged into one, and they're of equal application whether the judgment in question is English or foreign. He's misread what Lord Justice Gough said. And the respondent didn't disagree. The respondent picks it up at 622H, 1495. Pick it up just below C. Phosphate sewage, Boswell, Coates and Hunter are all cases on the approach that the English court should take on an application to set aside or otherwise challenge an English judgment. No criticism of Abeloff, we can probably go straight down to F. Fraud is regarded rightly by English law as a particularly offensive matter. There's a real distinction between fraud and other issues. The plaintiff who obtained a foreign judgment by fraud is not just a litigant who's benefited from a mistake of fact or law by the foreign court. He's a litigant who's deliberately caused a foreign court to come to a wrong decision. The general rule that foreign judgments are conclusive as to their merits, even if the judgment is wrong, may be justified as tending to increase the international enforceability of such judgments. It doesn't follow that it should be extended to benefit such a plaintiff. In the case of an English judgment, the defendant would have been found liable by the English court itself. The domestic rules are intended to prevent the same court being asked to retry the case on the evidence that either was or should have been before it at the first trial. The English court has satisfied itself on the evidence before it that the plaintiff's claim is justified and warrants enforcement. In the case of a foreign judgment, the English court has not reached any such decision. So, respondents' submissions were relying on phosphate sewage and Hunter, but probably applying them correctly, in that the advocate, Barbara Doman, was looking at a case where there had already been a decision on the issue. But if I may say so, the appellant's counsel mischaracterised the position under English law. Since it wasn't an issue up for argument and there was no proper debate and not complete citation of authority, it's not at all surprising that Lord Bridge said what he did.
Well, it would be very surprising if Lord Bridge had simply adopted a submission of counsel as the law without looking at the material that underlay it. I mean, I can quite see the force of your point that Lord Bridge got it wrong, but I'm not sure that being misled by counsel is the explanation. It's just judges get things wrong sometimes.
Yeah, fair enough, but he didn't have to look at it because it wasn't a live issue before him. So if it had been a live issue before him, I'm sure he would have got it right, not wrong. Then we go to the second Owens case, which is E44, 1508. What's that first reference? Oh, sorry, E1508, and for us it's in hard copies, it's A231.
Tab 34.
Tab 31.
Tab 31.
Yes.
This is simply the three-line endorsement by Lord Templeman.
Yes, and the judgment that we can find at 1512 at 627.
Sorry, page?
Page 627, or
Thank you.
1514, thank you. It's a very short passage. At C, an English judgment is impeachable in an English court on the ground that the first judgment was obtained by fraud, only by the production of established evidence newly discovered since the trial, and not reasonably discoverable before the trial. Sorry, it was 1512. I hope I haven't misled anyone. And he cites Boswell and Coates, but Boswell and Coates doesn't say that. We've already looked at it. It doesn't support at all the imposition of a reasonable diligence requirement.
So this is 1512, not 1514.
Yes, I'm sorry, it's at C,
Yes.
where starting an English judgment is impeachable.
Yes, I have it. Thank you.
And again, this was obiter. Hip, Fong and Junesco were not cited. And Boswell and Coates doesn't support that proposition. Then, my Lord, since Hunter, there have been a handful of first instance decisions, some of which have had arguments, some of which haven't, where the first instance judge has followed the interpretation of Hunter, which we've seen in Owens Bank and Bracco, and to that extent I say those decisions are wrong and should be overruled. I'd only mention, and I wasn't planning to take you to any of them, unless you want me to. I was only going to mention one, only because Lord Sumption appeared and argued in a slightly different context. The Hip, Fong and Junesco and Beard cases, the debate then was between what Lord Sumption was arguing as to the materiality of the evidence, the newly discovered evidence, on his corner, and on the other corner, whether the evidence had to be conclusive. Mr. Justice Langley thought there were two conflicting lines of authority and came down in favour of the conclusive. But that's the case of Sophia Drake and Orion. Just so you know where it is, you can find it at E1872 and at A4 tab 45. I was then going to take you to Zurich and Hayward. Zurich is at E2174, hard copy A4 tab 52.
Sorry, could you give me the electronic number?
E2174. Before looking at it, that's a case in which a compromise of legal proceedings was set aside on the basis that it had been induced by a fraudulent misrepresentation, and the representation being the claimant's dishonest exaggeration of the extent of his injuries. And my lords and my lady, its main relevance for present purposes is that the Supreme Court made it clear that there's no duty upon a defrauded representee to be diligent in determining whether there are reasonable grounds to believe the representation made. And we find that in the judgment of Lord Clark at paragraph 39 at 2190 and hard copy 1243. That 1243, paragraph 39, he accepts the submissions made on behalf of Zurich. In particular, I agree that a representee has no duty to be careful, suspicious or diligent in research. As Lord Justice Rigby put it in Betjeman and Betjeman, what is the duty of man to inquire? To whom does he owe that duty? Certainly not to the person who had committed the concealed fraud. Here, Zurich did as much as it reasonably could to investigate the accuracy and ramifications to Mr. Hayward's representations before entering into any settlement. And Lord Toulson, at 2193, page 1250, paragraph 73 at the bottom of the page, it was expressly conceded on behalf of the insurers for the purposes of the present appeal that whenever and however a legal claim is settled, party seeking to set aside the settlement for fraud must prove the fraud by evidence which it couldn't obtain by due diligence at the time of the settlement. It makes no difference to the outcome of the present case, and the court heard no argument about whether the concession was correct. Any opinion on the subject would therefore be obiter, and since the court has not considered the relevant authorities, including Commonwealth authorities such as Tubia and Schwenke or academic writing, it's better to say nothing about it. So we say the importance of this decision, my lords, my lady, is this: a compromise of proceedings may be undone on account of fraud, notwithstanding that the victim has failed to exercise reasonable diligence to detect that fraud. And applying that to the present case, had the parties compromised the proceedings shortly in advance of the trial, Mrs. Takhar would subsequently have been able to set aside, or seek to set aside, that compromise without needing to satisfy the reasonable diligence requirement. That being so, it would be extremely odd, we say, if her position differed, just because the Takhars had persisted with their fraud at trial and successfully misled the court in addition to Mrs. Takhar. And repeat the point made by Mr. Justice Newey about the principle first time round. Sorry, if the Christians had...
Yes, I think...
I do apologise.
No, I think we realised that.
Thank you.
That was a slip.
The point made that it would be very odd if someone could go to prison for forging documents, but still be able to enforce a judgment that is obtained as a result of his fraud. But that's the effect of the reasonable diligence requirement, or might be the outcome of it, if it represents the English law. My Lord, finally on this issue, I think...
Because that anomaly would arise in the circumstance where forgery was alleged but not established, and subsequent evidence came to light that could sustain a criminal prosecution. So it's...
But if subsequent evidence came to light sufficient to sustain a criminal prosecution, it would satisfy the reasonable diligence and the conclusive nature...
Well, it might, but it might not.
Well...
However, I think
yes,
that's a pretty small point.
Yeah, I get the point. My Lord, I ought to comment on the fact that Lord Justice Patten made extensive references in his judgment to the general principles of res judicata as outlined by the House of Lords in Arnold and Westminster Bank and Virgin Atlantic and Premium Aircraft. But however, as we point out in our case at paragraph 32, those cases weren't concerned with and didn't examine the test for setting aside judgments on the grounds of fraud, or the interaction between the policy in favour of the finality of litigation and the prevention of fraud. And in those cases, their lordships clearly recognised that normal res judicata rules do not apply where fraud in the conduct of the proceedings first time round is alleged. And in any case, Lord Justice Patten accepted that the problem faced by Mrs. Takhar is not one of issue estoppel, as this is an issue that hasn't been adjudicated upon before. So we say it's a little odd to be looking for the policy of the law in cases which aren't actually dealing with this particular issue, particularly where the authorities, properly read, make it clear what the position is.
Yes.
I've got a little over 10 minutes left, and in that time I propose to take you to two Commonwealth cases to draw your attention to the article written about the Court of Appeal decision by K.R. Handley, Fraud is a Thing Apart, which we respectfully suggest is very lucid and absolutely right. And I'm then going to say a few words about Ladd and Marshall and then sit down. And I think we start to Beer and Schwenke. We find that, I'll need help on the electronic. We'll find that in bundle 5, tab 61, 1487.
2449 electronic.
Thank you. And we need to pick it up at 1492. If I can give in perhaps internal paragraph numbering, that may help. If we can pick it up at paragraph 22, which is 2454, I'm grateful. Mr. Williams submitted that section 66 incorporated the requirement under general law that a party seeking to set aside a judgment for fraud must establish that fresh facts had been discovered since the judgment, which couldn't have been discovered earlier by the exercise of reasonable diligence. The short answer is that the section doesn't impose any such requirement. The longer answer is that proof of due diligence was not required under the general law in such a case. He then deals with the Owens Bank cases at paragraph bottom of 23, 24, cites some Lord Briggs, cites some Lord Templeton in paragraph 26. Both Parker LJ and Lord Templeman relied on the decision of the House of Lords in Boswell and Coates, but as will be seen, it provides no support for the proposition that proof of due diligence is required in an action to set aside a domestic judgment. That case is reported as Boswell and Coates and as a note to Birch and Birch as Boswell and Coates number 2. A submission that due diligence had to be shown was part of the argument of junior counsel for the successful appellant in Birch and Birch. His argument is reported, but as will be seen, this submission was not accepted by the Court of Appeal. The dicta of Lord Bridge and Owens Bank were cited by the Federal Court in Monroe. I don't think we need to go to that. He then refers to the article from Gordon, and I think we can pick it up now at paragraph 34. The decision of the House of Lords in Boswell and Coates provides no support for any requirement of due diligence in an action to set aside a domestic judgment for fraud, cites some Earl Surbon, then cites some Lord Justice Cosens Hardy and Birch, and at 37 he says, I would not follow the dicta in Owens Bank and Bracco and Owens Bank in Etoile and the Federal Court, even if there was no High Court decision on the point, because with respect, the dicta are contrary to principle and earlier authority. The assumption is that the court and the losing party were then successfully imposed on by the fraud of the successful party, but relief should nevertheless be denied and the judgment allowed to stand because the defrauded party was careless or lacked diligence in the preparation of his case. Such a result would be contrary to long-established and fundamental principles. Contributory negligence is not a defence to an action for fraud, whether the relief claimed is rescission or damages. As Mr. Justice Brennan said in Golden in Vagalas, a knave does not escape liability because he is dealing with a fool. Means of knowledge of the falsity of the representation without actual knowledge is no defence, and a representee has no duty to make inquiries to ascertain the truth. And cites from Spencer, Bauer, Turner, Handley. And he says at 39, the dicta in the recent English cases, contrary to earlier decisions of the Privy Council and House of Lords, which were not cited in those cases, and then refers to Hip Fong, then Genesco and Beard. And at 41, he says, in an action for fraud, a plaintiff must prove he was deceived, but need not prove that he was diligent. Where the action seeks a judicial rescission of a judgment, the plaintiff must prove that he and the court were deceived, and only he can do this by showing he has discovered the truth since the trial. Where this is done, the fresh facts are material, fraud is established. Lord Buckmaster said that if fraud was proved, the judgment was vitiated, and he can only have meant that nothing else had to be proved apart from fraud. This means there's no need to prove due diligence as well. However, the decision is foreclosed in this court by the decision of MacDonald, whose judgment was concurred in by Mr. Justice Quito concerning the requirement for granting a new trial on the discovery of fresh evidence. It's essential in such a case the appellant established that fresh evidence could not have been discovered by the exercise of due diligence, then continued, and I've already taken to the quotes from the Chief Justice and from Mr. Justice Menzies at 43. And also I've taken to the comments of Mr. Justice Menzies at 45. So, closely reasoned, and with great respect we say clearly right. That's been recently followed by the High Court in Australia in the Clone case, which you find at tab 58. 2358 is where it starts. Can I ask you, if you're interested in due course, just to read to yourselves paragraphs 45 through to 60, because that's where they deal with the historical survey and the distinction between original bills and, on the one hand, and on the other, bills of review. And I was just going to pick up the judgment at paragraph 63, and I'd ask you to read in due course 63 to 68, just noting that when they refer to the modern English position in paragraph 67, that's Takhar in the Court of Appeal. And they decline to follow it, and they say that approach hasn't been adopted in the course of the Australian decisions. And at paragraph 68, they say this: that approach hasn't been adopted in the course of Australian decisions. after the bill of review was superseded by the power of an appellate court to grant a new trial. In Australia, the absence of the conditions of due diligence was maintained for new trials based on claims of errors of law. Further, the condition of due diligence became only discretionary consideration in that limited class of case where a new trial was sought by application to appellate court based upon misconduct or fraud, although a case involving an allegation of fraud in procuring the judgment is more properly brought first as an original or fresh action. And just so you know where it is, the article written by Handley, Fraud is a Thing Apart, you can find in Bundle 5, tab 65, electronically, 2501, which is a review of Takhar in the Court of Appeal. My Lords, 5 minutes. I'll just say a few words about Ladd and Marshall and then 6 down. The other side's argument, for your reference there, paragraphs 49 to 66, we don't need to look it up, they say that the court ought to adopt the reasonable diligence requirement when deciding whether to set aside a judgment on the grounds of fraud, because such a requirement applies under the Ladd and Marshall conditions. We say that their argument doesn't adequately confront our submission that the jurisdiction to introduce fresh evidence on appeal is fundamentally distinct from the jurisdiction to set aside a judgment of fraud. And in brief, our argument is as follows. Historically, the introduction of fresh evidence on appeal was done by way of a wholly separate procedure from an action to set aside on the basis of fraud. We say that distinction has survived into the modern English law, reflected in the power of an appellate court to order a retrial and a fresh action to set aside judgment respectively. We say there are strong policy reasons for preserving the distinction between these two separate procedures, particularly as Ladd and Marshall is not determinative, whereas setting aside a judgment for fraud, you have to prove the fraud to the requisite standard. In any event, the case law suggests that Ladd and Marshall conditions are not immutable, and proof of fraud justifies the relaxation of the reasonable diligence requirement, even in an application to admit fresh evidence on appeal. And the justification for the distinction in this approach were 2 important points. Appellate court isn't in a position to conduct a trial when assessing the quality of the evidence sought to be introduced at the appeal stage. That's why it can only require that the evidence be apparently credible, though not controvertible. By contrast, an action brought to set aside on the basis of fraud, the fraud must be proven. So the policy balance is different in each case. Where fraud is not proven, it's justifiable for the appellate court to place more weight on the interest of finality. But by contrast, where fraud is proven, the balance of interest is weighted more heavily in favour of preventing the fraudster abusing the court's process. In any event, the jurisdiction to admit fresh evidence on appeal is discretionary and applies to all evidence, not just evidence of fraud. Ladd and Marshall does not lay down a set of strict immutable criteria. It's only guidance and can be departed upon when the court considers it just to do so. The test for setting aside judgments on ground of fraud, in contrast, is not discretionary. So long as the requirements are met, the judgment must be set aside. To graft Ladd and Marshall onto the test for setting aside for fraud is to ossify mere guidance into a hard-edged rule. And when going through the cases, it's plain that the courts have accepted that the reasonable diligence requirement in Ladd and Marshall can be suspended in the case of fraud. And we refer to the main cases there in paragraph 46 of our case. That's electronically E43. The main authorities, which I mentioned briefly in passing, I don't have time to go to, are Meek and Fleming, Scone and Scone, Linton and Ministry of the Defence, and Hamilton and Brodie. In each case, because fraud was an issue, the courts either did not apply ground 1 of Ladd and Marshall or were more flexible as to its application. And it's notable that these authorities, I'd better stand corrected, these authorities don't appear in Lord Justice Patton's judgment at all. There was no debate about this in the Court of Appeal. I will stand corrected, but I recollect it was very much the court that ran with this issue. So the court did not have the benefit of the citation of the authorities that showed that in appropriate circumstances where allegations of fraud are made, Nad and Marshall is not applied rigorously, and there is, in practice, a relaxation.
Yes.
I think I've run out of time.
Well, you've done very well. Thank you very much. Mr. Mould,
Thank you, my lord. I have no submission to add.
Mr. Sullivan.
Thank you, my lord. My lords, my lady, I intend in my oral submissions to follow the structure of our written case, and so I'll first address the current position as a matter of English law, then I'll turn to the reasons of policy and principle as to why that position should be maintained. Thirdly, I'll address the Commonwealth authorities. Fourthly, the issue of enforcement of foreign judgments, and then I'll conclude by addressing what we say would be the negative consequences if this requirement were to be removed. First then, as to the current state of the law, the appellants are able to point to only one English decision in which a judge has, in terms, held that the reasonable diligence requirement does not apply in this context. And that's the decision of Mr. Justice Newey, as he then was in the present case. By contrast, in the bundle of authorities, there are 2 Privy Council authorities, 2 House of Lords authorities, 2 Court of Appeal authorities, and 5 High Court authorities, all of which state the requirement as being unequivocally a part of English law. And 2 of those High Court authorities post-date Mr. Justice Newey's decision in the present case, but predate the Court of Appeal decision in this case. And so in both of those authorities, Mr. Justice Burton in the Chodiev case and Mr. Justice Snowden in the Ackerman case considered all of the case law, including Mr. Justice Newey's decision, including the Australian decision in Tubia, and considered that Mr. Justice Newey's decision was incorrect, and the correct position was the reasonable diligence requirement applies. And it's for that reason, in my submission, that the appellants are left to point to authorities in which the reasonable diligence requirement simply is not addressed at all. And they invite the court to read those authorities as thereby amounting to a finding that the requirement does not form part of English law. And we say that that is an unsafe and incorrect reading of those authorities. In fact, in those cases, which I'll come to, the reasonable diligence requirement was not mentioned because it wasn't an issue and because the cases failed for other reasons. First, though, the authorities in support of the requirement. And my learned friend has already taken the court to them, but I'll take the court to a few, simply to highlight the points that we raise in connection with those authorities. The first is the Owens Bank and Bracco case, which is behind tab 30 of the hard copy bundles, bundle 2 of authorities, and it begins at page 1460 of the electronic bundle.
Hard copy.
Hard copy, tab 30, bundle 2, page 595. The facts of this House of Lords decision are important in understanding what the panel decided. It was an application by a bank under Section 9 of the 1920 Administration of Justice Act to register a judgment from St Vincent and the Grenadines. And that was a judgment by which the bank had obtained an order that a respondent customer had to repay a loan. Now, at the original trial, the respondent had argued that no loan had ever been made and no funds had ever been advanced. And it was unsuccessful. But then, when it came to the application to register the judgment in this jurisdiction, the respondent challenged that registration on the ground that the judgment had been obtained by fraud, specifically that documents that had been deployed at the original trial had been forged. And in Italian criminal proceedings in the intervening period, there had in fact been a finding that the documents had been forged and the forgers had been sentenced to prison, suspended pending an appeal. Now, Section 9 of the 1920 Act expressly provided that the court can refuse to register a judgment if it was obtained by fraud. And the bank in the House of Lords argued that the Act must be qualified by the domestic common law rule that when a party seeks to set aside a judgment on the ground of fraud, it must show that the evidence it relies on could not, with reasonable diligence, have been deployed at the original trial. The very test that's before the court today. Now, in assessing that argument, which was the issue before the House of Lords, the House had necessarily to determine if the premise on which the argument was based was sound. Because, of course, if the reasonable diligence requirement when setting aside a judgment for a domestic judgment for fraud is not part of English law, then that would be the end of the case. And so I say that we can see in the judgment at page 1500 electronic, page 622M hard copy.
622.
M for Michael. This is a point that the House carefully considered. So just between E and F, the argument is set out in Lord Bridges' speech, the argument that I've just identified. And then between G and H, your lordships were taken in the course of argument through the many authorities in which this salutary English rule has been developed and applied, and which demonstrate the stringency of the criteria in which the fresh evidence must satisfy if it is to be admissible to impeach a judgment on the ground of fraud. I do not find it necessary to examine these authorities. The rule they establish is unquestionable, and the principle on which they rest is clear. We say that is an unequivocal statement which formed a necessary part of the decision-making process of the House. My learned friend can seek to persuade your lordships that it was wrong and that the 1966 practice statement should be invoked and it should be overruled. But in my submission, what he can't simply say is, because it's wrong, you can ignore it. We say it's an unequivocal part of the decision and it's part of the ratio. The next decision is in the next tab of the hard copy bundle and at page 1508 of the electronic bundle. That's the decision of the Privy Council in the Owens Bank and Etoile case. This was a case, it was a claim on a guarantee in France, and the defendant repeatedly sought to advance arguments on misrepresentation and fraud, first at the trial in France, then in a claim in St. Vincent, and then when resisting enforcement in St. Vincent. And the Privy Council held that that was an abusive process. But in the course of doing so, my learned friend has already taken the court to this part of the judgment, Lord Templeman set out the test that I have shown your lordships from the Owens Bank and Bracco case. Again, we say an unequivocal assertion of the reasonable diligence requirement in this context. Now, in support of that dictum, Lord Templeman refers to the case of Boswell and Coates, which again my learned friend has shown the court. That is the subject of criticism both by the appellants and by Justice Handley, writing extrajudicially and in the Tubia case in Australia. They say Boswell and Coates is not authority for the imposition of the reasonable diligence requirement in this context. Well, we disagree, and the High Court of Australia disagrees too. 2. So I wonder if I might take the court to Boswell and Coates, which is in the first volume of authorities behind tab 6, and it begins at page 925 of the electronic bundle. Boswell was a case involving allegations of fraud. In this case, it was alleged that the party had fraudulently suppressed evidence in an earlier action. Part of the appellant's case before the court today rests on the historical distinction between a bill of review and an original bill prior to the Judicature Act. It's common ground between the parties that prior to the Judicature Act, under a bill of review, it was necessary for the reasonable diligence requirement to be satisfied as part of the leave process. And this, of course, is the process that has led to the modern process of review. And if authorities needed, the case of Patch and Ward, which my learned friend has shown the court, is that authority. The Earl of Selborne in Boswell and Coates considered this. This was still, it's 1894, still at the stage at which the forms of action that had changed following the Judicature Act were being thought through. And the relevant part of his speech is at page 116D of the hard copy bundle, page 930 of the electronic bundle. Halfway down the page, it begins, the old practice of the Court of Chancery applicable to bills of review may not be, and I assume for the present purpose that it is not, now in use. A simpler and less formal and technical code of procedure generally has been adopted, which does not expressly require a preliminary application to the court when a proceeding in the nature of a bill of review to set aside a formal judgment, otherwise final, is taken. The same new code of procedure, while omitting to repeat the old rule of the court requiring leave to be given for the commencement of such an action, contains this other power of an equal summary nature that the defendant who is harassed by the action can apply to the court if the case be a proper one to stay its further prosecution. Pausing there, that is really the process which we envisage in the present case. If a party brings a fresh action seeking to set aside an earlier judgment for fraud, the defendant to that action can, at a preliminary stage, apply to strike it out as being an abusive process. The Earl of Selborne goes on. That is what has been done in this case. But then this. I conceive that the principles applicable to an old bill of review ought to be kept in mind and ought to be applied in their full force, and even with greater freedom than before, when an application of this kind, a fresh action, not a bill of review, is made, and then the application in question is the stay application. Well, the old bill of review includes the reasonable diligence requirement. By applying the principles to a bill of review in their full force to a fresh action, we say that the Earl of Selborne means you apply the reasonable diligence requirement. Now, this is a point which was picked up by counsel in the case of Birch and Birch, which is in the preceding tab of the hard copy bundle and begins at page 915 of the electronic bundle. And so this was a case just after the turn of the century, 1902. And at page 919, electronic 109 hard copy, the arguments are recited, and at point 6 towards the bottom of the page, counsel makes the argument that the old Bill of Review procedure should be employed when the court is dealing with a fresh claim. And he cites, amongst other cases, Boswell and Coates in support. Now, this argument isn't addressed at all by the Court of Appeal in Birch and Birch. It wasn't necessary to do so because in Birch and Birch, the Court of Appeal looked at the new evidence and said there's nothing in it. So it's about a question about the materiality of the new evidence. The court didn't consider the circumstances in which the allegation could be raised. The Court of Appeal did not dismiss that argument, contrary to the reading of that judgment given by Justice Handley in Tubia, which I'll come to. But in the Australian High Court, as I've mentioned, this point was considered in the case of Clone. And that decision can be found in the 5th volume of the Authorities Bundle, behind tab 58, at page 2376 of the electronic bundle. I should say the report begins at page 2358, but the relevant section is at page 2376, 1425 of the hard copy bundle. The decision of the High Court of Australia in Clone is that although they saw a historical distinction between the bills of review and an original bill, they considered that as a matter of English law, on this point, the principles had been amalgamated, and the same approach was taken to both. And that can be found at paragraph 67 of the report. It appears that the reason for the modern English position that reasonable diligence is required for the success of an original election to rescind a judgment for fraud has been based upon an assimilation of two historical sets of principles. And then towards the end of the paragraph, perhaps the earliest suggestion that these principles might be assimilated and treated even with greater freedom than before was by the Earl of Selborne in Boswell No. 2. That's the passage that I've taken the court to. So we say that criticism of Lord Templeman's reliance on Boswell and Coates in the Owens Bank and Etoile case is misplaced. In fact, we can see that whatever may have been the distinction between the historical forms of action prior to Boswell and Coates, for this purpose, the principles were amalgamated at that time. The next authority that I should take your lordships to is the case of McIlkenny and Chief Constable of West Midlands, which can be found in the second bundle of authorities behind tab 24, page 1304 of the electronic bundle. My learned friend has mentioned, I think, that this was the case concerning the Birmingham bombings in 1974, in which there was previously a criminal trial in which Mr. Justice Bridge, as he then was, held a voir dire to determine whether confessions by the accused were admissible. And the ground of challenge to those confessions was that it was alleged that they'd been procured through assaults undertaken by the police.
An allegation which was subsequently established in the Court of Appeal Criminal Division.
An allegation which was subsequently established, and
this may not be the best advertisement for the justice of the rule.
My Lord, I take that point, and I'll come on to the policy balance. I accept, and I should make this clear at the start, there is no
Also the
perfect-
case where Lord Denning uttered the deathless words, there would be an appalling vista if these cases were allowed to continue.
Well, my Lord, again, I take that point, and of course, and in fact, I think it was this case that led to the creation of the Criminal Review Commission. Of course, that's not directly the issue before the court today, because here we're dealing only with setting aside civil judgments, and we say there is no perfect answer to the competing policy interests that are in play. But when I come to address that, we say that on balance, the current test is the best balancing exercise of those competing policy interests. And there are other mechanisms that the courts can use to ameliorate some of the problems. In McIlkenny, which was the subsequent civil action brought by the, at that stage, convicted men against the police, the Chief Constable applied to strike out on the grounds that the points had been decided and that the civil claim amounted to a collateral attack on Mr. Justice Bridges' decision following the voir dire. The relevant part of Lord Justice Gough's judgment, as he then was, begins at page 1354 of the electronic bundle 499 of the hard copy bundle. Now, my learned friend has taken the court through the dicta here, so I don't propose to do that all over again. It begins at about point C on page 1354, and then runs all the way over to page 1356. The relevant point in my submission begins towards the bottom of page 1355. Lord Justice Gough, having considered the authority...
Is that page 500?
500, I'm sorry. Considers that the fraud and fresh evidence points merge into one in the context of that case. And then considers, well, what should the test be? It says the defendants say it's the estoppel test. Alternatively, they say it should be the Ladden-Marshall test. And he decides the test to be applied is the test that includes the reasonable diligence requirement. Page 1356, 501 hard copy at C. He's not saying there, I'm applying the estoppel test because this is an estoppel. That would be, there wouldn't be any need to consider the alternative options. He is considering, in my submission, in this judgment, the question of in what circumstances should a collateral attack on an earlier decision be permitted? In what circumstances should an earlier decision be revisited when the evidence could and should have been deployed at the original trial? And so we say that his dictum is of general application and specifically applies to the question of whether and when a judgment can be set aside on the ground of fraud. And that, of course, is the construction that's been given to this case by the Court of Appeal in the present case and by each of the High Court decisions that we've referred to on the point our written case. And as my learned friend has shown the court, this point was expressly approved by the House of Lords in the Hunter decision. I appreciate just two more cases on this point. The first is the Privy Council case of Ultimo, which begins, which is the first bundle of authorities behind tab 3, begins at page 855 of the electronic bundle, 45 of the hard copy bundle. This was a case involving jurisdictional issues as to the enforcement of a Kyrgyzstan judgment in the Isle of Man, and questions as to where disputes as to the validity of that judgment should be resolved. So I accept that this is not a case in which the point was directly being considered, but it is another unequivocal statement of the principle by the Privy Council, and that can be found at page 883 of the electronic bundle, page 73 of the hard copy bundle in Lord Collins' judgment. Paragraph 109. The rule for impeachment of English judgments requires that the person seeking to impeach the judgment produces newly discovered evidence which could not have been produced at trial with reasonable diligence. And that, earlier on in the paragraph, you can see is dealing with the question of judgments being impeached for fraud.
Which paragraph?
Paragraph 109.
109.
Yes.
Yep, I got it. Thank you.
And finally, although we rely on all of the authorities that we set out in our written case, of course, the authority that I would specifically draw the court's attention to is the case of Ackerman, which is found in bundle 1 behind tab 2, beginning at page 825 of the electronic bundle, page 15 of the hard copy bundle. This is a case in which my learned friends appeared, I think arguing in my position today. We respectfully adopt the analysis of Mr. Justice Snowden to the authorities. I don't propose to go through it orally, but for you, the court's note, it begins at paragraph 64 of the judgment and concludes at paragraph 80, and it takes in the relevant cases, so say, including Mr. Justice Newey's decision and including Tubia. As I say, we adopt that analysis. Now, as against the various, we say, unequivocal statements of the principle at every level of authority in this jurisdiction and in the Privy Council, the authorities that my friends rely on principally are Hip Foong Hong and Jonesco. First then, Hip Foong Hong, I think I ought to be able to do before a short adjournment. That's found in the first volume of authorities behind tab 16, beginning at page 1153 of the electronic bundle. The background to Hip Foong Hong, it was a claim for failure to deliver opium in China, and the claim in China failed. The judge accepted the defendant's witness evidence and documentary evidence that the contracts in question had been cancelled. But after the trial, new witnesses came forward and there were new documents discovered which indicated that the defendant had used fraudulent means to obtain evidence at the original trial, specifically unlawfully obtained search warrants. So a new claim was brought by the unsuccessful party to set aside the judgment, which was refused. Appealed to the Privy Council, that was refused too. And the basis for refusal was that even if fraudulent means had been used, it would have made no difference to the outcome of the trial and the new evidence was insufficiently material. This case is dealing only with the issue of materiality. And we say that that's an important point to consider when one is reviewing all of these cases, because there are two controversial issues when one is considering the test for setting aside a judgment for fraud. One is the reasonable diligence requirement, which is the issue before the court today. The other is the issue of materiality, which is sometimes in the authorities adopted by using the language of causation. And so one can see in Lord Buckmaster's speech at page 1158, electronic 322 hard copy, what he was concerned with in this case. About between the third and halfway down the page, he expresses the House's disfavour regarding the method of collection of evidence, but then cites with approval the conclusion of the court below that the evidence there was nothing in it. About 3/4 of the way down the page, the documentary evidence which has been discovered and which was primarily relied on does not carry the case far, and it is now more bolstered up by unsatisfactory evidence, which will only become more unsatisfactory with the lapse of time and the increasing opportunity for contradiction. A second trial must in many ways be less satisfactory than the first. Then he goes on to consider the appellant's argument as to why that part of the decision below should be departed from. The appellants refer to the earlier House of Lords decision in Brown and Dean. And they say, well, in that case, when an application is made for a new trial on the ground of discovery of new evidence, the evidence must simply be at least as such as is presumably to be believed, and if believed, would be conclusive. That is addressing the test of materiality, and only addressing that test. And so when one then goes on to read the remainder of Lord Buckmaster's speech, and that includes the section that my learned friends rely on, he is drawing the distinction between a case involving fraud or surprise and a case which does not involve those elements in order to justify a different materiality test. And so when he sets out the test, all he's thinking about is materiality. He's not giving any thought at all to the prior question of whether the reasonable diligence requirement should be fulfilled. I think, my lords, that may be a convenient moment.
Right. Sit again at 2 o'clock.